Mr. Tadlock, good morning. Mr. Tadlock, you're here because you've been accused of 2 counts of lewd and lascivious battery, a person over 12 but less than 16 years of old and 16 years old, and 1 count of lewd and lascivious molestation within the same range, over 12 but less than 16. Your mother, your father, and a couple of other friends or family members are in the courtroom. Ms. Jordan is also in the courtroom. I want to tell you, I have read the complaint, Mr. Tadlock. There is probable cause in the complaint. I think I'm the judge that read it initially and issued the warrant. In addition to that, on your criminal history, there's a reference to a prior similar charge, a sex offense, that is. And so I went back and read the most of the file in the Washington County case, so I'm somewhat familiar with that. This morning, Ms. Jeffco with the State Attorney's Office has advised me and the defense that she has filed a motion for pretrial detention. That's been filed, and I've also been advised that Ms. Taggart, it's not Ms. Taggart, Ms. Jordan now, right? Ms. Jordan would like to be heard. So Ms. Jordan, if you don't mind, if you'll come on up, ma'am, I'd be glad to listen to anything that you want to make sure we're aware of. Right here so he can see and hear you too, please. Thank you. Yes, ma'am.
Good morning, Your Honor. My name is Michelle Blankenship Jordan. I'm an attorney practicing here in Jackson County as well as across the Panhandle. But today I'm not here in my capacity as a member of the Florida Bar. I'm here today in my capacity as the mother of the second known victim of the predator that sits before you today, Tyler Jerome Tadlock. Tyler was introduced to our family by my cousin Mandy when he was 4 years old, and we welcomed him into the family with open arms. Tyler spent many days at my home as a child. My children loved him as a cousin. We celebrated when his dad and my cousin were finally married. But in the fall of 2018, Tyler would do something that would forever change the lives of everyone in our family, but particularly the life of my then 8-year-old daughter. It was the afternoon of an early release day in October. Because my son and Tyler were in the same grade at school, and Tyler's dad and stepmom both worked in another city, we offered to pick Tyler up from school and let him stay at our house until they got off work. At the time, I was operating my law office from home, and I had a house full of adults. The entire 3rd floor of my home was my children's playroom. On that 3rd floor, you could find my daughter's play kitchen, washer and dryer, high chairs, baby bottles, cradles, and her baby dolls. She loved playing house more than anything. That afternoon, Tyler waited for my son to leave the room. He unplugged the security camera with a speaker and a microphone, and he blocked the door with the TV. He asked my daughter if she wanted to play house. Of course, she agreed. But what she didn't agree to was having her pants pulled down, being pinned to the floor, and being raped by her 13-year-old cousin. She made her disclosure to me on December 22nd, 2018, but it would take another year before she would play with her baby dolls again. It took almost 2 months for Tyler to be arrested after her disclosure. We had to take a different route to school every day because if she saw Tyler, all the color would drain out of her face and she wouldn't talk the rest of the day. When I got the call on February 12th, 2019, from investigator Kenny Brock with the Washington County Sheriff's Office that Tyler had been picked up at school, had confessed to raping my daughter, and was sitting in custody at the Washington County Jail, a wave of relief passed over me. That relief would be short-lived. Because of the damage to the juvenile facility in Panama City from Hurricane Michael, Tyler would be transported to Crestview, where he would appear before Judge Brown in Okaloosa County the next day for his first appearance. And even though Tyler scored for pretrial detention, DJJ recommended it, the state attorney's office asked for it, and the public defender agreed to it. Judge Brown looked at Tyler and told him, "Son, I believe you did what they say you did, but your daddy is here today with you, so I'm going to let you go home." No one let us know about the first appearance. No one let us know that he was released that day. DJJ informed Tyler that he could go back to school with my children. Thankfully, I had the foresight to call the school principal the day of Tyler's arrest, and she assured me he would never come back to her school, and she kept her word. On Friday, February 15th, I checked the mail. In it was a letter from DJJ notifying me of my daughter's rights as a victim of crime and including a phone number for Tyler's probation officer. I called the officer immediately, and that was when I was informed, finally, that he had been released to his father's custody. The same father who was well aware that his son had been investigated in 2011 for child-on-child sexual abuse against another female family member. The same father who never warned us that his son had a prior history. The same father who never warned us that his son was already addicted to pornography at 13 years old. The same father who blamed my husband for not supervising his son. My daughter was absolutely devastated to learn that Tyler had been released after she'd been assured by everyone involved that he was in jail and would stay there until his trial. She had started trauma therapy almost immediately after her disclosure in December, and this would set her back weeks in therapy. Despite hiring an attorney for my daughter, despite intervention from the Marcy's Law for Florida Foundation, Judge Lucas Taylor refused to put Tyler back in detention. After nearly 2 years of legal involvement, Tyler was finally sentenced to a residential facility for juvenile sex offenders and was ordered to a detention facility to await a bed. He would spend a total of 3 months in a detention facility before being released to what amounted to a summer camp for juvenile predators. 3 months was all that my child was worth to Lucas Taylor. I stand before you today having walked this path before, knowing about the second chance that DCF gave Tyler in 2011 because of his age, knowing about the third and fourth chances that Judge Brown and Judge Taylor have given to Tyler, again because of his age, begging you not to give him any more chances. He will be 20 in November, and he has well established himself at this point as a predator. He knows exactly what he is doing, and he fully believes that he will get away with it. In January of this year, Judge Taylor released Tyler from supervision with no notice, no hearing. He didn't even serve a copy of the order on the state attorney's office. But even though Tyler's case involving my daughter might be legally over, it's not over for my daughter. She is devastated today because despite her bravery in coming forward, despite her bravery in telling her story, not only to authorities, but also publicly to support other survivors, Tyler has raped again. Had Judge Taylor acted appropriately and sent Tyler to a detention facility for the rest of his youth, there would be no third victim suffering today. My child is devastated today that yet another child's life has been turned upside down to satisfy Tyler's sexual perversions. She feels helpless and betrayed. I'm begging you today not to do this to another survivor. Although she has a legal right to be here today, you shouldn't have to be told by a rape victim that she wants her rapist in pretrial custody. She does. Tyler's proclivity for sexual violence is evident by the fact that he could not even go a year off of supervision without being arrested for yet another sexual battery on a minor. Tyler's proclivity for sexual violence was evident in the psychosexual evaluation conducted through the Department of Juvenile Justice. For a multitude of reasons, he was rated moderate to high risk to reoffend, and now he has. We found out yesterday that Tyler has been living less than 2 miles from our church, a sanctuary for my child, a place that was untouched by Tyler or his family, a place that offered her safety and comfort. But we have unknowingly been driving by him every Sunday morning. I'm begging you today to give my daughter the peace that she deserves. I'm begging you today to give the victim in the case the peace that they deserve. I am begging you today to hold Tyler in pretrial detention. It is time to stop being willing to sacrifice more children to this man. His family has proven themselves completely incapable and unwilling to adequately supervise Tyler. I'm asking you today not to trust them anymore. Tyler is now a grown man. It's time to put him away with other grown men who have made the same choices. His chosen attorney can come visit him in the jail just as easily as he can visit him at home. Pretrial detention does not violate any of his rights, but will protect other children in the community from harm during the course of this case. In full candor, I am the county attorney for the county jail where Tyler sits this morning. If that brings you any level of discomfort, I would ask that you not release Tyler, but instead move him to a facility in another county. Thank you.
Thank you, Ms. Jordan. Does Mr. Tadlock's family, anybody want to be heard? You either do or you don't. It's up to you. Okay. All right. So, Mr. McDaniel, on the motion for pretrial detention, I read the motion this morning. I went and read the rule. Ms. Jeffcoat's here on that case, and it's not my job to rule on it. I do have a question or a concern. That rule is a little bit confusing, Ms. Jeffcoat.
It is, Your Honor.
In one place, it mentions capital life and first degree felonies, and in one place, it just mentions dangerous crimes. So he accused of dangerous crimes, but he's not accused of a first degree or higher. Is that right?
That is correct, Your Honor. The charges that he is currently charged with are all second-degree felonies. The state is proceeding under the dangerous charge rule. We believe that the state will be able to show that he poses a threat to the community based on his prior history of similar acts. And also there is another subsection that I don't have enough information on yet to include in my motion, but I believe the allegation dates are after he was released from probation. But I spoke with the victim's guardian yesterday, and she indicated that some of his, he definitely befriended the child and maybe started some of the grooming behaviors while he was still under the supervision of DJJ, which gives the state huge concerns about his ability to not reoffend while on a court-ordered supervision or pretrial release of any sort.
Okay. And according to the complaint, he's admitted to the latest allegations.
He did, Your Honor. He made
Consisting of
admissions to
3
both.
second-degree felonies.
Correct, Your Honor.
Okay. Anything else, Ms. Jeffcoat?
Nothing further at this
All
time.
right. Mr. McDaniel, anything?
Nothing, Your Honor.
All right. Mr. Tadlock, I'm going to find the state's filed a motion for pretrial detention. There's certainly a basis to believe that you may be fall under that statute. You may be a danger to our community. So I'm going to hold you with no bond until Judge Garcia can have the hearing. Under Florida law, that hearing takes place within 5 days. And we got an email from Judge Garcia. I believe that hearing is going to take place the latter part of next week, Wednesday or Thursday, perhaps.
Yes, Your Honor.
So I'm going to ask the state and defense to coordinate that hearings. Mr. Tadlock, you'll be in front of Judge Garcia next week for a full hearing on a motion for pretrial detention, but there's certainly enough evidence for me to make a preliminary decision that you need to be held with no bond due to the danger to the community statute. Mr. Tadlock, do you have any questions?
No, Your Honor.
All right, sir. Wish you the best. Thank you, Ms. Jordan. Thank you, family members, for coming.
And Your Honor, for Mr. McDaniel's benefit, just so he knows, I will go ahead and get a copy of the CPT today and get an information filed so that the PD's office can be appointed and maybe Mr. Blunt or one of the other assistant PDs can handle that hearing.
All right. Thank you, Ms. Jeffcoat.